So there's legal questions in public debate, and so I thought I would try to knock together one of these videos relatively quickly. This video is all about the Commonwealth emergency powers, and I'm planning to cover three things. First, how do emergency health directions work under the Biosecurity Act 2015? This is the question that doesn't get asked very much in public debate. Second question gets asked all the time is it constitutional? And although it gets asked all the time, it's an insanely boring question for reasons that we'll cover. Finally, the most important question, and the one that I think gets asked the least, what is the proper role of the court here? But underpinning all of this, I want to emphasize one really clear message, and that is that there's a difference between social dimensions of a question and the legal dimensions of a question. Even if everything is completely lawful, our political system is designed on the basis that politicians will behave in a way that is both lawful and morally acceptable to the wider community. And a lot of people, for whatever reason, start with their moral reaction. I can't believe that this is legal. And then they bake in a legal reaction. This is definitely not legal. And it happens regularly with constitutional law controversies. But before we get too far ahead of ourselves, let's get the details right. What are we even talking about? The government has announced that it is making it an offence for a person who has been in India for the past few weeks to come to Australia. And importantly, it is proposed that this will apply to Australian citizens who are returning to Australia. And this is the part that has really fired up people's imaginations. The problem basically begins with this guy here, the Premier of Western Australia, Mark McGowan. And from what I understand from media reports, an Australian went to India at the end of last year to attend his own wedding. And when he returned a week or so ago, he went into Western Australia's hotel quarantine and tested positive for COVID. And then due to a failure in Western Australia's administration of its own quarantine program, COVID spread, and there were concerns that it might have spread to the community. Premier McGowan's response was that this was somehow the fault of the Commonwealth for allowing a person to travel to India for their own wedding at a time when the rate of infection was fairly minor. And he wanted to renege on the arrangements currently in place for managing quarantine in Australia, which I covered in one of my earlier lower quality videos. In a nutshell, under our legal framework, administering quarantine is a state responsibility, but the Commonwealth did have the option to oust the states entirely by relying on a grey area of law. And this gets me to one of my core issues with Australian federalism. If everybody points the finger at the Commonwealth when the states stuff up for their service delivery, why shouldn't the Commonwealth take on greater powers and responsibility? But let's get back. It gets to these two guys, Adam Zampa and Kane Richardson, and they're cricketers who were in India but flew to Australia via Doha. I definitely do not want to make the claim that they did anything wrong, because for all I know, it was completely innocent and was not designed to skirt possible travel bans. And there's no sarcasm here. Like, I really don't know their circumstances. I actually don't really know who they are, and I don't want to defame them by suggesting that they did anything wrong. So, what options are available to stop people from doing what these cricketers did? Well, under our federal system, there's also a question about who has the power to affect these options. Now, one option that is available to the Commonwealth is found in Chapter 8 of the Biosecurity Act 2015. This chapter contains two powers, and I'm going to focus only on one of them, the human biosecurity emergency powers. So it says that the health minister gets a bunch of special powers if there is a human biosecurity emergency, which, due to the global pandemic, it is not controversial that there is a human biosecurity emergency. Now, Section 477 of the Act says that during a human biosecurity emergency period, the Health Minister may determine any requirement that he or she is satisfied is necessary to prevent or control the disease. Now, there's a common intuition that emergency powers are just legal magic, that there are no rules, the government can do what it likes, and that we're 10 minutes away from murdering the Jedi younglings. But it's not. There are rules. And although the Health Minister may determine any requirement, the Minister must be satisfied that the requirement is necessary. So this is a limitation, but it doesn't get you all the way home. Here is the Premier of Victoria, Dan Andrews, along with Premier McGowan from before. Both states used similar powers in their health legislation to do basically what the Commonwealth Government is doing here. Premier Andrews famously slammed the door shut on Victorians who happened to be anywhere in New South Wales when there was an outbreak in Sydney. Premier McGowan did a similar thing, but less prominently and through a curlier method. So we're seeing the corresponding power at the Commonwealth level. And we have some case law about these powers. As you might have seen surreptitiously before, here is Clive Palmer. He recently lost a High Court case challenging the Western Australian provisions that restricted the ability of people to move across borders. It's important to be precise about what this challenge was. Mr. Palmer was making an argument under Section 92 of the Constitution that says, on the imposition of uniform duties of customs, trade, commerce and... Hang on. Section 92 is famous for needing an edit because very, very little of it is still operative. So let's get out the red pen. Nice. And that leaves us with trade, commerce and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. Not surprisingly, Mr. Palmer lost his case because Section 92 is not a suicide pact. There are limits on this that most people, I think, would think are pretty reasonable. But that's for another time. What's for now is a basic question that's still live. Can states use their emergency powers to exclude their own citizens? And if they can, what are the limits on that power to exclude citizens from going to their own homes? This question was not covered by the High Court. And this gets us back to Section 477 of the Biosecurity Act. Not only do we have this mental fact that needs to exist before the minister can use this power, Section 477 also includes a lot of explicit safeguards. The requirement must be appropriate and adapted to achieve the purpose. The requirement must not be more restrictive or intrusive than is required. The manner in which the requirement is applied is not more restrictive or intrusive than required. So that's the last one there. So the health minister is not given a blank check, and it gets us into an intellectually serious discussion. I think it could go either way on the question of whether criminal penalties for Australians trying to return home from India really are appropriate and adapted for managing the spread of COVID. So here's the quick, boring question. Are the health minister's powers constitutional? We've already started to hint in the direction of this question. The challenges to state emergency powers that excluded people from moving around the place were upheld by the court. Not only did Mr. Palmer lose his case, but this guy, Julian Gurner, also challenged Victoria's emergency powers, arguing that Section 92 guaranteed the right of Victorians to eat at his restaurant in Melbourne. Again, he lost because Section 92 is not a suicide pact. But again, this was the question that wasn't tested. is there something inherent in citizenship that means that a state or nation is unable to prevent your entry into its territory? At the moment, there is no bright legal light on this, so it's open to the court to say that there's something in the concept of citizenship that acts like a protection against unreasonable exclusion. But let's be really serious, if it does, it's going to use this same proportionality testing that we've already seen in the Biosecurity Act. So there's no gain by engaging in the citizenship question. We instead focus on whether these elements of Section 477 are met. Easy. Homestretch. This is the High Court of Australia, except it's not. That's the National Library of Australia. This building here is the High Court. And here is the current Chief Justice of the High Court, Susan Kiefel. Except, of course, that's not Susan Kiefel, that's Baroness Hale, former President of the Supreme Court of the United Kingdom. This is Justice Kiefel. So this is a joke that I've clearly stolen from John Oliver. But it serves an important point. Most Australians think that their High Court looks something like this and could not name, let alone identify, the judges of the court. So when it comes to emergencies, who should get the final say? The government, who through the principle of responsible government is elected by Parliament. So this Parliament here, the democratically representative institution of the state. Or should it be the High Court, who are unelected law lords who in no way represent the majority of Australians? And I put this in inflammatory terms to fire up the intuitions. At the end of the day, during an emergency when there are major questions to be asked, who should make the call? Somebody that you can vote out or somebody that you can't? Who is better placed to make the call? The minister who has the entire resources of the public service to give advice and information, or a bench of judges who don't? The name of this debate is parliamentary sovereignty. Should the democratically elected end of the state prevail over the undemocratically appointed end? And it's a problem that you should have in your mind when you think about emergency powers, such as the ones discussed in this video. Do you want the health minister to have the unfettered powers to keep Australia COVID-free, or do you want to constrain that power to the policy views of judges whose only experience is that they know the law really, really well? So, this is a debate about which reasonable people can have reasonable disagreements. The version of the argument that I just gave is the big, bold pub talk side of parliamentary sovereignty. But let's focus more on the details here. When Parliament enacted the Biosecurity Act and included these provisions about constraining the power of the minister, it was not for show. It was done entirely with the view that these constraints on the power are there precisely because they are so draconian and extraordinary. Yes, we can have some reasonable concerns about the High Court maybe going on a frolic and inventing some hitherto unknown aspect of the law of citizenship completely at odds with the expectation of the wider Australian public. But this is not a real problem here. With the powers being exercised by the minister, so this is not a problem with the powers being exercised by the minister. Parliament, representing the broader electorate, has the expectation that these powers will be constrained by law. So here's Mr. Palmer and Mr. Gurner again. Can you imagine the public debate that would have erupted had the High Court found in their favour? Remember the glee that was expressed on social media when Mr. Palmer lost his case. In some instances, it was even worse. How dare he even challenge the Western Australian government's health directions that are keeping the citizens of Western Australia safe? And I suspect there would have been a great deal of hostility from the public towards the court had it found in his favour. So let's wind this up. What's the take-home message? The emergency powers are broad, but they are not unlimited. And we have already agreed in the Biosecurity Act that these powers should be constrained by law. We have a reasonable disagreement about whether the penalty provisions on Australians returning home from India are proportionate, reasonable and adapted. And it certainly looks arguable on its face for the court to go either way on that decision. We don't need to entertain the constitutional argument because everything we need to challenge the power is already in the Biosecurity Act, and the Biosecurity Act already envisages a role for the court to review the use of the power. Okay, very, very quickly, one last thing. There's an unusual provision lurking in section 477, it's this one. Basically, unlike all other legislative instruments that ministers are delegated to make, this one is not subject to disallowance. Section 42 of the Legislation Act sets out the process for Parliament to say, hey, we think that this delegated legislation enacted by the minister goes too far. As we are the democratically elected branch of government, we are going to strike it down. But here we see that Parliament's role is restricted. The minister makes the determination and Parliament can't knock it out. My personal view is that this is probably a mistake. Sure, emergency powers need to be as broad as reasonable, but Parliament definitely should have an oversight role to ensure that these powers are not misused. So that's it for this video. I hope it helps inform your thoughts about where you stand on the use of these powers, and that you can see that there's reasonable room for disagreement on a few of the issues related to the law there. I am at Legal Reckoning on Twitter if you want to discuss this more. Until next time, bye bye.